Hey, you have Patrick Findaro, managing partner at Visa Franchise. Excited to have on John Pratt as well as Jessie Marie Schreier, both attorneys at Kurzban Kurzban, also based here in Miami, Florida. John and Jessie, thanks so much for joining today.
Thank you very much for the invitation.
We're excited to be here, Patrick.
So before we started and turned it live, we're talking a little bit about our audience. It's a lot of prospective business owners, whether they're residing abroad in Colombia, Mexico, wherever in the world. We've had clients from 60 plus countries. And then there's also folks that are here on an F1 visa, student visa, maybe a B1, B1, B2, and they're looking to move fast and they're looking at different options so they can stay here. What are some visa options that prospective franchise business owners should explore in 2023?
Correct. I mean, to me, there's the most basic one and the most used by people that want to get a visa and have it tied to a business, which is the E2 category. And the E2 category obviously is based on a treaty between the United States and their home country. And there's a lot of different countries that have treaties, especially in Latin America. You got, Mexico, and you have a couple other countries that have it. But in Europe, you have a lot of other countries. So, like Italy and Spain and France and the UK. So based on that treaty, someone could try to obtain a visa if they're running a business in the E2 category. And a lot of times the advice is a franchise because it's a running business. It has a business plan. It has already the scheme of how many employees, what products or services, etc. Another category that is useful and advice is in the EB5 context. There's the EB5 direct investment, whereby someone also can run a business. There, the requirement is that they have 10 full-time employees. But the advantage of the EB5 is that could lead to a green card. The advantage with the E is that it's renewable forever as long as the business is active, but it doesn't lead to a green card directly. You could have it for the rest of your life, but you're not going to have a green card and you don't have citizenship. But both of those type of visas obviously can take advantage of a franchise specifically because both require to run some sort of business that has employees, that sells products or services, and the visa is somewhat tied to the success of that business. Another category that we have seen and we have advised clients a lot more often now, specifically since the last administration, is in the L context. Because the L visa at a basic level is a company that has a presence abroad and the person is a manager and executive for that company, and they come establish a subsidiary or an affiliated company in the United States. A lot of times, for example, let's say you were running a construction company or whatever type of company in the home country, pick any country. Then you wanted to start it in the United States. If you don't have the structure, the hierarchy of the employees, the Immigration Service only gives you a year to have that L visa, and then a year later you have to show that it's grown sufficiently. And the realities on business obviously is that businesses do not grow that quickly, and you don't have the pressure of having to have a number of employees, etc., which could obviously affect how that business grow because you have a payroll and you don't have the hierarchy, etc., because the L is for managers or executives. You have to have people under you. So a lot of times we work with corporate counsel and the client, and one of the advices is if you're not buying an ongoing business, obviously a franchise is a great mechanism because at least a franchise generally already has the business plan. It has some of the logistics as far as some of the prerequisites of a bit of an appropriate business plan, which is competitors and market analysis and different things, including payroll and personnel and some of these other things. So those are three basic visas where the immigrant becomes an owner purchasing a franchise or operating a business where obviously they still have to create an LLC or some sort of legal entity, and they could create it in any state. Now, one of the advantages with the L is that there's no You don't have to have a treaty country. You could be from any country in the world in order to do an L. But you do have to have that relationship between a foreign company in the country and a U.S. company, and they both have to be active. The E, you don't need to do that. You just need to have the source of funds, show that your source of funds is legitimate, is clean to some extent, but you don't have to have a business outside that you don't operate. The other thing I want to say is obviously about diversification is that it allows you some flexibilities if there's issues related to the business later on.
That was an interesting point, because on the L's, it's almost always someone that doesn't have a passport of a treaty country, where we've had Brazilians do the L1 visa, Indians do the L1 visa, Chinese do the L1 visa. But we've had quite a few clients start with an E2 visa and then go up to the EB1-C, where they get that, whether a Mexican for 4-year E2 visa, or many nationalities, it's a 5-year temporary visa. And then they go to, I guess, what would be the L1 visa equivalent, the EB1-C, and get the green card that way.
Correct. And all of those are mechanisms that you could try to do. But, what we have seen since the last administration, and for example, we have several cases that we're appealing in federal courts right now on EB1-C denials and L denials, where they started being a lot more careful, especially in the EB1-C context. So if you don't, you want to start a restaurant and you don't get the liquor license on time, so you didn't open it on time. If you're running into that year because you started a new business, and at the, when you get to the renewal, you still have 0 employees or 1 employee, and you couldn't open because there was a hurricane in South Florida, or, whatever the case may be, you may have certain problems extending that L. And what we have found in some instances, if you have a hierarchy where you have maybe a holding company and one subsidiary is the franchise, and then you're doing whatever your export business or whatever your other real business interest was, that it allows a higher likelihood, obviously, by showing the complexity of what you're doing in the United States, to get the initial L, to get extensions of the L, etc.
Would that be possible in like the EB5 context? We haven't done many EB5 directs over the years, but there's been like a big surge of inquiries now, where people, maybe they have $1 million net worth, they don't want to give $800K to someone else through a regional center, and they want to run their own business. They want to have 100% control over their business. But one concern has been, it's taking 50 months for the I-526, and then it's taking, I don't know how many months to remove the conditions on the green card. What happens if I want to sell the business or close down that business? Can you use that approach, that kind of like holding company approach, in the EB5 context, where you're doing different activities, or does it get complicated?
No, it's a great question, and you can. The regulations in the EB5 context establish that you can have a holding company with wholly owned subsidiaries. So, the EB5 law right now, as it passed last year, requires a minimum investment of about $800,000, requires a maximum investment of $1.05 million, depending on the geographic location where it is. But to follow on what you said, so what about if I set up a holding and 2 subsidiaries? One is a franchise, whatever the franchise is, and it costs me $500,000. And then I spend another $300,000 or another $600,000 in a different business. If I create 10 jobs among all my subsidiaries, if I spend the requisite amount of capital on all the subsidiaries to the holding, then I would be eligible to have an EB5. The other thing that I would say is that IRIA, which is the law that extended and amended the EB5, did something really that can be very helpful. Because if you have someone that is a student in the United States right now, or someone that has another type of visa in the United States, what EB5 did is it allows concurrent filing with an I-485. So you're correct that an I-526 will still take like 5 years. But if you are legal in the United States and you have that kind of capital and you set it up as a structure, whether you buy a franchise for $300,000, $400,000, and then you make other investments or you buy 2 franchises. Sometimes, and you still may want to diversify it, because if something happens in one franchise, it doesn't touch the other one. There's also some corporate reasons to do it that way because of limited liability, etc. But in the what I'm saying about the concurrent filing that it allows you to file for the adjustment of status with the I-526, and it allows you to stay here. And even though it's pending the green card, the
you
I-526,
can travel, you can work, your spouse
you can travel,
work.
you can work, your spouses eventually will get to work, your kids can go to school, etc. So, even if it takes 4 years, you now get to live in the United States, and you now get to enjoy the benefits of the United States. And it's something that obviously the law appropriately changed last year to allow for that. There's very nuances of when you came in and all that. So obviously consultation with a proper lawyer is warranted to make sure that you do it appropriately.
I had a recent consultation with a Indian-born H-1B holder who's in the line for the EB2, but I thought it was like 12 years. He says, no, Patrick, it's like 50 years at the current count. I'm like, man.
Yeah. And there's the Indians are one of the highest categories on EB5 right now, because because of the EB2, EB3 backlogs, they have jumped into the EB5, for example, in order to try to get a green card. Unfortunately, there was such a demand for Indians that there's now some backlog, not as long as the EB2, EB3 backlog for them, but there are some. But for example, that's one of the advantages, especially from people from Latin America, is that the EB5 is current for people from Latin America. The only 2 countries that are a little bit oversubscribed is, you're talking about the People's Republic of China, you're talking about India, you're talking about Vietnam. One of the things that they have to be careful, though, when you're doing an EB5, and to some extent a need to, is the source of the funds that are used for the business. Once you get into the green card aspects of the visas, they're a little bit more careful, for lack of a better word. So sometimes you just again need to have the proper counsel in order to anticipate and correct some of the issues relating to source of funds and how funds moved in order to capitalize a business.
So this has come up a few times where someone has the 800K or the $1,050,000. Ideally, they don't have to spend all that much money, but they're going to create the 10 jobs. And, EB5 might be current based on where they're living. And they might be eligible for the EB2, but that now is not current. So if someone had 800K, but it's like a home health business that it really requires 250, and you're going to create like 20 plus jobs, but you could make it where you find reasons to spend the 800,000 with all the employees and different expenses to get to the 800K. Could someone start with the EB5 and then also try with the EB2 NAW or other green card petitions, or is that not advised to kind of hedge your bets with which green card petition gets approved fastest?
Yeah, let me answer the first part of it, which is, when you file the business plan on the EB5, you're going to have to explain to the EB5 unit. It's called the IPO, the Immigrant Investor Program Office. You're going to have to prove with your business plan that the full 800 or the full 1,050,000, depending on the geographic location, will be needed, and that will create the 10 plus jobs. So you really obviously need to be transparent to the government of how the money is going to be spent in order to create those, that many level of jobs. Now, whether, let's say, for the sake of argument, just a stupid example, let's say, for example, argument that the 300 will create it in that labor intensive business, but I'm spending 300,000, but I'm spending 500,000 in developing some software that may increase at 5-10 years from now. Is it that legitimate? It's legitimate. What you cannot make is a fraudulent statement. And for example, there was a case whereby there was a franchise that was really about 200,000, And eventually immigration realized that they were fixing the numbers to make it seem like it was really 500. And they got hit with fraud, and the SEC got involved. So again, I mean, the first part of it obviously is if you spend the 800 or the $1,050,000, which part of it created the jobs? I would say is the whole amount, but it's the whole amount as it relates to the business or businesses, because again, I'm talking about a holding. So if the holding has two branches, one is the labor intensive restaurant with the 10 people and that cost me X, but the other one is I'm developing some app that one day will be the similar at WhatsApp, but that takes years. Those are all legitimate. You see what I'm saying? Now, one may create 11 jobs, the other one may create one, the guy that's creating it, but you win. So, so I just wanted to lay that out. The second part of your question is, what if I am on my way for one type of immigrant visa? Can I also apply or seek another immigrant visa? There's nothing in the law that prohibits that. So the bottom line is, and the perfect example is what we just talked about, Patrick, which is you had Indian nationals that were in the EB2, EB3 line, for lack of a better word. But because it's taken so long, they now are jumping into the EB5 line without getting out of the EB2 or EB3 line and seeing which line comes out quicker. So the bottom line is, yes, absolutely. You can look at different immigrant visa options to see which one comes out quicker. Again, I would say, I'm not trying to sell anybody on EB5. I'm just simply saying that before concurrent filing, the problem is you had to wait 30 months, 50 months, 60 months outside of the United States to get an EB5 benefit. Now that's no longer the case. So, it changes the game a little bit in terms of some people.
What are some creative ways you talked about a bit, but just structuring in terms of like maximum flexibility so that someone could maybe not close doors to different green card options if they want to have that available to them and their family in the future, as well as just business decisions. How can they keep the green card open and also run a profitable business at the same time and not have to keep all these jobs if it's not needed?
Yeah, I mean, one of the things that I think and we've been operating and with the advice of the corporate lawyers is to really have a holding company with subsidiaries. And I'm going to give you one example. We had a pretty successful businessman who had an E2 visa through Argentina. Argentina is an E2 treaty country. And he was running through a holding. He was running several movie theaters. And the one industry that was the most affected during the pandemic, I think that even more than even restaurants or anything, was movie theaters. They shut down. So when the renewal came about, obviously, the law is somewhat inflexible because it doesn't allow acts of God. For example, I had my business and there's an earthquake. Too bad. You don't have your business anymore. And if an E and you're seeking for an E renewal, act of God is no excuse. Pandemic is no excuse. So what he did at that point in time, because he had a holding and the E came through the holding, he went and bought some gas stations. He felt at that point in time that, even in the worst pandemic, until all the vehicles are electric, people need gas. So now, again, that because it was at the holding, he could go buy another franchise. And when it came to the Visa E2 renewal, well, the E2 is still operating through the holding through different franchises. So he was able to, so it gives you a little bit flexibility. It also gives you, let's say for a sake of argument, you're running, 2 restaurants. Do you rather have 2 branches of the same restaurant, or you want to have 2 corporations that own a restaurant? And there may be some business reasons why you may want to have 2 corporations, because if one of your restaurants is in Coral Gables and the other one's in Miami Beach, and one person gets food poisoning and they sue you, they're not going to be able to touch the assets for the other business. So there's business reasons to do it. There's business immigration reasons to do it. Now, the next part that you said, Patrick, is the issue which, okay, but I want to pursue an NIW. I want to pursue something else. that again allows you that flexibility to do it, because as an owner, do I have to work for my business? No, I don't. Obviously, if I'm being employed by someone else, there may be issues that why would you want to work for someone else in an AB2, AB3 category if you're a business owner? Well, I mean, there may be reasons that you can prove it, etc. So it allows you certain flexibilities, because obviously, again, you're the business owner, so it would not preclude you. I joke sometimes that if you're Bill Gates, but if you're Bill Gates and want to live in America, will you be willing to work for some company? Yeah, that doesn't make it frivolous. Now, there may be issues that are raised by immigration to find out, is that really a bona fide business? Are you really going to do that? Yes. And like you said, in some of the NIVs, for example, you could do it through self-employment. You don't have to have a sponsor or alien extraordinary ability, but you will have to show that whatever your extraordinary ability is, you're going to keep on doing in the United States. One of those mechanisms may be through your own entity.
And I'm glad that is like. Oh, I'm sorry. Go ahead, Patrick.
No, just a growing trend. Just people getting the NIW and being based on job creation, and how they've created 50 jobs in Venezuela, and they're going to be doing a similar thing in the US, and they're going to hire 20 people in the next 2 years and getting the EB2 NIW, and really focusing on that job creation aspect.
And that's what I want to touch on, is that NIW, because I think NIW could be a great vehicle for your own skills, but it's really not the magic cure-all. And sometimes I think, John, we were having this discussion a few weeks ago about everyone who thinks they're a pilot, they can get an NIW, or there's certain fields that are more apt to an NIW application, but it's really for those applicants who have very specialized skills. They're so well known. They have accolades, they're easily found online, and you have to convince that it's worth waiving the job offer.
And what I'll add to what Jessie said is, look, you could, regardless of the process that you tried with immigration, and Jessie has some of the statistics that are very, but regardless of the process that you have in immigration, there's immigration risk, and immigration risk entails with an agency that is not always coherent, or how would I say it, consistent in their adjudications. So sometimes, like I have clients that say, I have 3 L's and I got them approved, but they're denying my EB1-C, saying that I was never a manager. I'm not a manager. And what I can tell you, because we litigate cases in federal court, and very few immigration lawyers do that, but we do it here all the time. You cannot win, and you will not win a federal court litigation by simply going to a federal court and saying, immigration gave them 3 L's, but they denied the EB1-C on it. Because what immigration would say, so what? Incorrect adjudications. And you cannot rely on an incorrect adjudication in order to win the next one. So what I'm telling you is that, and especially on the NIW context, I've been in meetings, and Jessie's, I heard it, that any pilot can get an NIW. So,
that's what it's being marketed as, in some countries, and
I would say Brazil. I heard that any Brazilian pilot,
exactly.
I mean, even if you fly a Cessna, you don't have to fly a 747. All of them.
But that's, I think, an important thing for people that are watching is, like, who are you doing work with? Like Jessie and John have been a firm that's been around for what, 30 years plus?
More, with the founding partner, Ira, created it back in the 1970s. So I would think close to 50 years. But you really got to get a good lawyer. I mean, there's ways to try to be creative, obviously, and in being creative is perfectly fine. And you could always try to educate, because part of our job is to educate immigration about what your field is, what your accolade is. Not everybody wins a Nobel Prize in chemistry. Nobody has an Oscar. Not everybody has an Oscar. But there's ways that you could document it, and you could try to prove it, and you could try to show whether it's an NIW or national interest waiver or alien extraordinary ability. But there is also the immigration risk that even if we believe you have a strong case, immigration may see it otherwise and not approve it. The only other thing I would say, and it may be diverging a little bit from the topic, but a lot of times you have people that are outstanding in one area, but they're no longer outstanding in that area because they, and the perfect example I would tell you is, Maradona. Maradona was a great soccer player, but Maradona, 10 years after retirement, could he get an alien of extraordinary ability as a soccer player? No, because he doesn't play soccer anymore. So especially in the sports, a lot of former sports, Major League Baseball players from Venezuela try to get those type of things, and they may be as coaches, they may be able to get it as something else. But again, getting proper legal representation and someone studying it, and you lose nothing by trying, is what you were asking initially, Patrick. That sometimes you could try 2 or 3 different avenues and see which one is the most effective. I'll harp back to franchises, because franchises, obviously, it allows, especially in some of the countries that we're talking about that are having certain pressures, maybe Colombia, maybe Peru, where people want to get an immigration solution, but they also want to have capital that they put to good use to make money, and having, and coming as an immigrant, what business, where do I set it up? What's the success rate of new businesses, which is, it's very tough. So sometimes a franchise, it gives you a little bit more flexibility and reliability, in my view, because they're tested businesses, right?
Yeah, and it's like a client I just interviewed. It's much more predictable, like the head count and like the revenue, where he went from 0 to clearing $1 million in revenue in 2 years, where like for our company it took like 5 years to hit that, where you can do it in a more predictable fashion and usually faster with a franchise. But talking about the risk, it made me thinking, what is the risk of someone that applies for a green card and they're denied? Like, are they going to have issues getting non-immigrant visas in the future? Like, if you get denied an EB1-C or whatever green card category, is it hard to get a non-immigrant category later?
There may be situations where it is, but let me back up a little bit. It depends on where you're applying to, because you have people, for example, that we have seen this. What we get a lot of times too is, in our firm, is how to fix a problem case that someone, I joke with Jessie and some of the other associates that we're like the Mission Impossible people, where you get the recording and it says, you take this case or it's going to self-destruct. So that's the case. But if you file an NIW, and you could do the I-140 concurrent with the I-485, but then you get it denied and you have no other status. Then what ends up happening is, once the I-485, once the I-140 gets denied, you're out of status and you start accruing unlawful presence. And that could have some severe consequences, because after having unlawful presence for 180 days or over 365 days and you depart, then you're ineligible. You may be able to do something under a specific section called 245K, that way you could do another employment base if it's less than 180 days. So one of the implications that is critical is, where is the person? So if they denied your I-140 or your immigrant visa in the United States, where is the person? What was the status of the person? What kind of visa does the person have? In order to determine, can you stay? Do you have to leave? Or if you're outside, you're just going to have to wait for another one. The second thing is, obviously, now that you sought an immigrant visa, non-immigrant visas that have a requirement that you have to have a foreign residency abroad and all these things, it could have implications, because obviously on an F, you have to have a foreign residence abroad, and you don't have the intent to immigrate. They could say, wait a second, but you try to get a green card. Now, could you overcome that? You can, by showing, what? Yes, I did. I lost, but now I'm running my business in Brazil. I'm doing everything in Brazil or Peru or Colombia, wherever it is. And my kids are here. And I really just want to go as a tourist, because I want to take my kids to Disney World. Is it possible to convince an immigration consulate? It is possible, but it could be issues. I wouldn't say that it's fatal, but it's very specific on what you're doing. The only other point I wanted to add, though, is and we have seen, and through some of the the associations that we belong to, we've seen an increase is the application of a section of law called 214B, and we saw one example of 214B be applied on an E context, and I had never seen it in my 20-year career before that, and that was last year, whereby, as you know, the E2, you don't have to have a foreign residency abroad, but it's still a non-immigrant visa. It could be renewed as long as the company's here, et cetera, et cetera. But there's been reports of E2 visa denials in Paris and in Rome, and in different ways. And I was speaking to a former pretty advanced or a high level guy in the Department of State that Jessie and I have worked on a couple of cases, and he was indicating that yes, it can be denied, and the reason why it was denied in that case is because the father had an E2 for many years, and the kid had lived with the E2, but when the kid turns 21, they lose derivative E2 status. So the father gave him a substantial amount of money, over $500,000 to invest in his own company. And the company was legitimate and it was active, but the kid was not attending college. He was only 21. He had never run a business before. And, what I presume happened is that the U.S. consulate in Tel Aviv, is the officer thought and said, you've been living in the U.S. since you were 7. You're now 21. Daddy gave you the money. There's no way. And how do you overcome that? Well, in theory, if you got a 214B denial, it's kind of like a death sentence, but you could reapply. And this is where the factors come in, Patrick, whereby, one of the things that I advise a client is, look, let him go to college, get some, let's get him an AA degree in business management. Let him run a business in Israel for a couple of years. If the factors change, then obviously the money's legitimate, the business is legitimate. But we have seen, 214B denials, and I recently heard about an O visa denied on the 214B, where 214B is being used to deny some visas at the consulate. That's why sometimes, because 214B cannot really be denied or used, or I have not seen it ever, on an adjustment of status, that if you're here in the United States and you could pursue an adjustment of status. And again, obviously, if you're here in the United States on F, can you change to E? Yes, that's called a change of status. But if you want to adjust status and get the green card, then NIW, editor extraordinary ability, EB5, it would be some of the appropriate mechanisms.
You brought up a good point. And just like we've had our first denial, and we've never had a final denial where someone tries twice, but was a Pakistani national, and he had never had a B1, B2 visa before. And knowing what I know now, it seems like that might have been a red flag. And I've heard that like a lot of Pakistanis don't do consular processing and do adjustment of status, and maybe it's for that reason.
Yeah, the consulates obviously, because there's a doctrine that's called consular non-reviewability, and if you get a visa denied, it's very difficult to go into immigration or to go into federal court and challenge it because of consular non-reviewability doctrine that may prevent you from going into federal court. So a lot of times you have a little bit more rights. There's a case called Patel that the firm represented in the Supreme Court last year that changed a little bit on the landscape, but you still have more rights sometimes to pursue an adjustment of status if you have an immigrant visa attached to it. So, again, I think all of these things that we're discussing, Patrick, or what type of visa, what type of franchise, what type of business, really requires a whole team, because we do the immigration stuff. You find the appropriate franchises or businesses but they need a corporate lawyer or a business lawyer to set up the different entities, And another thing that I tell people a lot of time, okay, so fine, I know what to do. I'm going to enter into some contract to rent this. Well, I'm not a business lawyer, and I mean, you should have a person looking at that.
Yeah, we have in our contract at Visa
wanna get
franchise, you must hire a franchise or corporate attorney because you're signing a lease for like 5 and 5 years, and then franchise agreement 10 years. Like, you need someone that really knows what they're
correct.
doing that
And
just does
what
this.
happened, for example, during the pandemic, a lot of times was, in a lot of these commercial agreements, they were pretty inflexible. We don't really care that your restaurant went bankrupt. You got to pay the lease.
Yeah.
So knowing what you're in for, I mean, without proper representation, you're going blind or guessing. And United States is very formulist.
Small businesses, you can lose more than you invested. It's not like a stock. You invest the capital. Say you invest $100K for a franchise for U2 Visa, you could lose all that, and then you can lose another $100K.
Correct.
And people don't realize that. And basically, the lawyers act as an insurance policy to cap that downside of what you could be losing.
Absolutely, and those are great points. Another, sometimes I have clients that say, well, I'm going to have some business partner, and we're going to be 50-50, or maybe in the EB5 you don't have to have controlling interest, and then you have to explain, look, I mean, you could be locked out in some cases, so you have to consider the corporate law angle. And in addition to that, for example, in the E2 context or the EB5 context, we've had clients, once you spend too much time in the United States, you start paying worldwide taxes. So we've had situations where the investor says, you know what, I'll have my wife apply for that green card or to stay permanently for that, because they'll start doing their tax planning because they're making too much money outside of the United States. And another thing to consider, obviously, and a lot of your clients are high net worth individuals or people that want, but may have other business interests or assets outside of the United States, is proper tax planning.
And Jessie, I know you've gone through a ton of stats over the years, but especially in light of the pandemic, the visa issuance stats. And I think that'd be interesting for everyone that's joining us today. We're already getting some questions about approval rates from some of the people dial in. But what have you learned from your recent study, looking through the recent visa trends?
Well, I think, just as a preface, in talking about minimizing risk, and you both brought this up, it's become more of an option, and sometimes case specific, of course, but it could be preferable to do a change of status because of some of the inconsistencies at the consulates with the visa issuances. So, like John said, I think consulting with the appropriate professionals before you choose your path, whether it's change of status or consular applications, is key. And then look at your audience, because the consulates are, according to the statistics, they are exceeding pre-pandemic levels in terms of visa issuance. But with that comes inconsistent adjudications. That comes, inexperienced consular officers. And particularly in some of these consulates that just started doing E's, with the new treaties prior to the pandemic, they really have no experience in the E1 and E2 context in Israel and New Zealand. So, I mean, that's where minimizing the risk, consulting with the professionals comes in, and then possibly even looking at third countries if you have the means or the eligibility to kind of get out of maybe some of the stickier consulates and the longer waits. But I know you want the numbers because they are good. We want to give good news. So 2019 February, pre-pandemic, no one had been affected by anything at all. We had US visas, non-immigrant only, worldwide. We had 628,000. So February 2023, we are at 853,000. So we are doing great.
We're open.
We're open. Bogota is back. They are open for E2s, although they report 0 E2s and E1s issued in February, but they're going to go on a first in, last out. So things are looking positive, but it's really become, what's the best case for your business, for your passport and your specific circumstances.
And before we jump into a few of the questions from our audience, what are some of the best ways to prepare for the visa interview? And I know your firm extensively helps applicants, and I can't say that about every immigration law firm. What are some best ways to prepare for that interview?
I think know your audience is, as we touched upon, the consulates and what they're doing, but know your record. At some consulates, or most, I should say, you may just have 15 to 20 minutes at a window counter with a consular officer. So you want to be organized. You want to be able to specifically pull out your financial documents, know exactly what they're going to be looking for your category. And some people don't put much stock into the consular web pages, but they have become very detailed, very helpful. And so take a look with your representative and just be ready and organized to answer what could be a 5 to 20-minute interview, and know your facts. And with that, as John said, we have a lot of problem cases. So don't hide from the issues, because that's going to be the focus of your interview. If there was any type of negative decision in the past or anything that has been alleged by the consulate or even USCIS, just be able to clearly explain what happened and have your facts and your evidence ready.
Yeah, I'll simply add to that, obviously, in specifically in the, reading the tea leaves, because when the consulate denies you, that they just, especially on 214B, you get 214B, they don't tell you why. And in the E context, as you know, Patrick, obviously, was the investment substantial? Was it not marginal? Do you really have the management, and etc.? So if you get a 214B denial, it wasn't denied under any of those substantive requirements theoretically. But it goes back to what Jessie just said and harped in, which is you got to know, if you're doing an E2, you got to know your business plan. You got to know what you're selling, what products or services, what your level employees, because you got a couple of minutes. And if the officer says, how many employees do you have? And you're like, you just really, so you really got to know your business plan, and reading the tea leaves. When we were preparing that client, a lot of these, oh, don't worry, but I'll be ready for the interview. I mean, and I would tell him, listen, if the worst moment you have is in front of us, we did our job. The reason why we're prepping, and I'm asking these questions not to antagonize you and to, take you away from your surfing, tonight, because the guy's a surfer. But again, and I said to him, listen, if you do this, and who knows what happened at the consulate, but you really, preparation is key, knowing what's in your visa application, knowing about, and the other thing I would say is, no matter how much you prep people, it doesn't matter how much you prep people, there's things they don't tell you. And what the consulate is doing now, especially for some of these, NIVs and some of these employment visas, is they're going back many years when people were applying for other visas, like tourist visas. And they're looking at inconsistencies. Hold on. In the L in 2019, you said you were a CEO for a company from 2012 to 2017. But on the B2 for 2015, they said you were a photographer. And, it doesn't serve you to lie to us, or lie because the consulate may find out about it. And, sometimes there are explanations, sometimes there aren't. But being aware that you did apply for other visas in the past, and consistency, of course they're going to look at those type of things.
And as we talked about 214B before, obviously, as John mentioned, there's no appeal for that. And you don't really necessarily know why, which aspect of your life was deemed to show immigrant intent. But for some other bases of denial, there is a mechanism to go to the legal department of the Department of State, if it's a legal basis that you can argue. The problem that we see in some cases, particularly L's for startups, is you only have a year for your new business. And so if you didn't have the proper documents, or you gave some type of information that led the officer to incorrectly deny the visa, then and even if you had the petition approved, you could appeal, but it could be months, and you're left with a few months left.
So I want to be mindful of your time. Do we have maybe 10 minutes to go through some questions?
Absolutely.
So the first question from Gaston Laguna. which visa has the highest approval rate and the shortest approval time?
Jessie may be the statistician here.
Well, are you applying for a B1, B2 in Mexico? No. I mean, it's really dependent on your circumstances, your evidence, and your classification. If you have multiple nationalities, if you are a Cuban or Venezuelan living anywhere in Mexico or residing in Mexico, you can have your choice of consulates in some cases. But I do want to caution some of our listeners. We have heard reports of visa appointments being scheduled through the online systems, and the person shows up to the interview, for example, in Mexico, where there's a dozen consulates, and the person says that was a mistake. We're actually not adjudicating this classification of visa. So I would take everything with a grain of salt. Talk to your representative, and I've had great success even calling the consulates, shockingly, and just confirming appointments. They can even assist you to reschedule over the phone. So yeah, Gaston, it's a good question, but it's really all over the board. The more options you have versus one nationality, or one, if you have student status, or if you have residency in a third country, if you have derivative citizenship, etc., that's going to be the shortest approval time, is the more options you have.
Correct. The one thing that I would add is this, and there's statistics that USCIS publishes as far as some of the visa categories, etc. But there's really, I guess the devil's in the details. So let me give you an example. For example, in the L or the EB1-C category, they give you the statistic overall. But when you get into practice, obviously, on the EB1-C, on the L category, you could have Fortune 500 companies doing Ls. And BMW North America sending an executive to BMW Germany and vice versa. I'm sure that their approval rate is closer to the 100% versus a small mom and pop shop where I had a garage fixing cars in Venezuela, and I have a garage fixing cars in South Beach, because what we've seen is how they're more strict in those type of categories. In the E2 context, for example, a lot of times, depending on your nationality, your source of funds get higher scrutiny, versus being a European who is in a country where the banking system is more formal and etc. Versus, for example, someone that may come from the Middle East, where the halal system is allowed for, or what they call informal currency exchanges, because there are restrictions to get capital out. So even within the rates, there's fluctuations that happens because of certain nuances based on the nationalities of the countries. For example, there's some more cash-based economies than others. So we have seen, and we, because we consult with a lot of lawyers who've had problems, we have seen, fluctuations in those approval rates. So, to answer that question, to be honest with you, and to just simply rely on an approval rate, I think it's a little bit skewed, because it depends on how strong you can document your case to increase your specific chances of getting the visa, regardless of where you come from.
That's well said. I mean, we've seen that with the E2 for like Japanese companies sponsoring E2 managers, or Siemens like bringing over E2 managers.
Like butter.
Yeah. So, I mean, that's thousands of visas that should be getting approved at 99.9%, where business owners is not going to be, that high. But it goes in, in terms of the origin of funds. The next question we have: what is the best way to approve the origin of my funds? Do I have to do it with an accountant, with a lawyer? Who do you recommend, John or Jessie?
Yeah, earlier in my career, using accountants was not common. But to be honest with you, no lawyer is as nuanced or as educated in tracing funds and whatever as an accountant, to be honest with you. So in a lot of these, especially in the EB5, we rely on an accountant to do a forensic analysis. And there's two concepts that I'm going to explain. One is, how did I make my money? Could I show through my tax returns and other how I generated my money? So I was employed by Siemens, and they paid me $1 million a year, okay? And I did that for 5 years, so I made $5 million. That could show that how I earned my money, right? Now, how the money moves is different. That's called path of funds. And we've seen more adherence to that in the EB5 than the E2. I've seen it in the E2, but I've seen it more in the EB5, whereby they said, okay, even if you could show that you made $1 million from Siemens, prove to us that the $750,000 or the $1 million that was in that bank account came from your employment from Siemens. So unless I have a wiring me my $1 million every year into that bank account, I may have a path of funds problem, or what they call a break. So it's very, sometimes you really got to look very hard, because the other thing that they're doing, and a lot of it in the EB5, it could be used in the E2, but a lot of them in the EB5 is, okay, fine. I bought a company. I had 70% shares of this company in Brazil, and this company made X money. Oh, really? Well, how much did you buy the company for? Back in whatever? Okay, but I invested 100,000 in 1970. Show us that that money was clean. Now you're going back to 1970. You see what I'm saying? So sometimes it becomes pretty hard. And, initially when we're filing now, I would rather, because I don't have to show, total wealth. I have to show the amount of investment in whether E or EB5. So sometimes it's better to create a bank account where it's not commingled, because we've had other situations that we have litigated in the EB5 context where even if I could show that Siemens paid that $1 million into bank account, if there were $10 million in that bank account, it just got commingled with other money. And immigration says, show us where that money was come from, because they want to make sure that it didn't get commingled with drug money or with illegal money. And that just becomes really hard. So again, and I'll answer this, because a lot of people tell me, but John, you're really hard. I've been to a gazillion lawyers. And the only thing I can tell is because the inconsistency of adjudications in immigration, a lot of it goes through until it doesn't. And what I said to clients sometimes is like going on I-95 and getting a ticket. If the policeman stopped you, your defense cannot be everybody's going faster than I was. I mean, if you're going 70, you got the ticket. So to avoid immigration risk, we prefer to use accountants and document it. The last thing I will say is, okay, so I bought an apartment in Colombia. I bought it. I bought it for 100,000. I sold it for $1 million. They may want to see a market valuation. Was it really worth 100 when you bought it? And where did you get that money? And was it really worth $1 million when you sold it? So it depends on where your source is. You may have to use accountants or other professionals to document it.
So we just have time for a couple more questions. Gabriel is asking, is it better to partner with someone already that has a business in the US to apply for the investor visa? Like, is there a higher chance of approval in that scenario?
I think what you really got to look at, obviously, is, and you have to do some due diligence if you're buying a business or whatever, looking at the tax returns, looking at the liabilities, and looking at some of the other things, because it's really, in my experience, it's the viability of the business that they're really going to look at. The other thing that partnering with someone that's running a business is if you're buying a franchise or buying a business with someone that's been operating it successfully for 5 years, the likelihood that they'll operate it successfully for the next 5 years, I would think, is somewhat good, because they have operated it, versus someone that doesn't have a track record. So I think in some of the intangibles, it may be advisable, but it's not necessary. I mean, then you're in franchises, Patrick. If I go ahead and buy a Chevron, and I have the guy to run it there for me, it's pretty solid, right? Versus,
yeah, I would say ideally, if you want to make real money from the business, you own 100%. You bring in the manager, you're running it, especially in the beginning, like the first 18 to 24 months. But if you don't have the time, you're one of those mega wealthy people that are counting their days, then yeah, you could look to have a partner. And we have some franchisors where they take a minority stake in the business, or some sort of operational support agreement can help you. But it's going to be, customized. And we have a question from Suarez Sophia. on if we offer personalized advice, what industry, and that's similar to what John and Jessie do. It's all personalized. We went through a bunch of visa options today, but no two individuals are the same. It's the same with our clients at Visa Franchise, where out of 10 clients, 8 of them will invest in different franchise concepts. And it's throughout the whole United States, different cities, states. We have resale opportunities that we can evaluate. So it's definitely very personalized. And then just the final question from Nicholas. Hey, good live. I have a question. If the green card is denied, do I have to go through the process again from scratch? Thanks.
Yeah, I mean, again, it depends on whether your I-140 was denied. So I'm assuming that the question is, if the immigrant with the I-526 or for the EB-5 or the I-140 for that is denied, can you appeal that? You could. Could you then sometimes do federal court litigation? You can. So there's some appellate processes depending on where it is, if it's outside or not outside. We talked about consular non-reviewability. So depending on where you are, you may have some appeal rights. Sometimes you have to start from scratch. And that's why I think it's always advisable to look at more than one process if you can. And, the downside is it costs you more money. It costs you more money maybe in lawyers and different things. But it may save you time in the end, because obviously if your ultimate goal is to get a green card in the United States, exploring different options, and because all of them carry some risk, whether immigration or business. And the last thing that I'll say, beyond answering the question is, and you touched upon it, one of the things obviously with franchises like you, Patrick, do is exit strategies, because people say, okay, I got my green card. Now I'm a citizen. Do I have to be operating it for the rest of my life? Well, if you invested in 100, a million, whatever, I mean, someday you want a return on your capital. And if the business did good, and if it had an operator, and if it's performing, you'll be able to sell that asset. That's an asset, that you could maybe sell and use the capital and not lose your capital. So you want to operate it successfully all the way through the immigration process so you get your green card. And you may want to have an exit option at some point.
At least have the exit in mind, where at our sister company, Vetted Biz, we have the resale values of 2,500 franchise brands. And sadly, there's a lot where it costs more to open a new one than the resales. So for example, Subway, right now, they're not accepting E2 visa holders, but you can buy one for like $150K, where to open a new Subway is $350K. So why would you, I don't think it's a good system to get into, but if you were set on Subway, why would you start one from zero when you could buy one for $150? So that's a really key thing is, okay, you're building a business. And if it's like a home care business where you start for $150, but they're usually doing $1.5 million in revenue, 18% profit margin, people are selling them for $800K, $1 million. That's a nice return on your capital. Correct. But if you start a restaurant for $500K and people are regularly selling them at $500K, why are you going to go through all the headache of finding the site, permits, construction, all that stuff, when you can just buy an existing franchise business without all those uncertainties on the time that it takes to open up? Obviously, if you just have $100K, there's not much available in terms of resales, but getting at the $150, $200K, there's more options that open up.
Absolutely.
Any concluding thoughts, John, Jessie, for those looking to make the track to permanent residence in the U.S. and then eventually U.S. citizenship?
Yeah, I'll start and I'll turn over to Jessie. Obviously, using a business, using a franchise, opening a business is a great way to try to get both a non-immigrant visa if you're planning to stay here for significant periods of time. Partnering with someone good and finding a viable business is also a great strategy for capital, to preservation of assets, to make money to some extent, etc. And looking at resale values. So exploring those options is really something critical in order to establish both your long-term or your short-term and long-term immigration goals. Partnering with the right people and with the right advice is critical to achieve both, again, the short-term and the long-term goals. both on your capital side of it. The last thing I will say is that a lot of people ask me, well, the safest way is to just buy a condo, put it in the stock market, I suppose, although the stock market is not so good right now, but it cannot be a passive business for most of these. It has to be an ongoing entity where you do have employees, you sell products or services, etc. So again, it has to be a viable business that you will run, or you will have the right people to run it for you. And obviously finding that is very important. Jessie?
And I'll just end on a positive note. We have talked a lot about non-immigrant consular visas, and I think now is a great time. I mean, the consulates are functioning at a level, it's not perfect, but it's much better than it was just a few years ago. And we didn't really touch on immigrant visas at the consular level, but they are extremely backlogged, much more so than non-immigrant visas. So in terms of consular operations, I think now is a good time, and nearly all the proposed improvements and ways to improve consular processing that have been announced this year and last year are solely targeted at non-immigrant visas. So I think it's a great time to plan and to consult and to talk with your appropriate professionals.
John, Jessie, I learned a ton in our hour conversation. I'm sure everyone listening, we had some great dialogue. What's the best way for someone to get in contact with you too, if they want to have a consultation and potentially engage your services?
Okay, they could go to our website, which I think is www.kktplaw.com. You know, our contact information, Jessie's and mine, emails are there, or the phone number, and set up a consultation. Because like you said, Patrick, each individual has different needs: short-term, long-term, family, tax implications, and you know, one size doesn't fit all, and you really need to. But if part of the investment is, you know, engaging someone like you, Patrick, is critical, because finding franchises, in my view, you know, franchises have been used in the United States just to make money. I mean, people own franchises in the United States. U.S. citizens own franchises in the United States because they want to make money. So it's a great marrying of the two worlds: my capital needs with my immigration needs, and you know, they can contact us through our website. Like I said, is, I believe, correct me if I'm wrong.
We'll include it in the description too.
Okay.
It's just 4 letters: KKTP Law. Very easy.
Perfect. Well, thanks again, Jessie and John. I really appreciate it.
Thank you, Patrick. It was a great conversation.
Thanks for the invitation.